Now we're all trickling in one by one. I never like to waste actual lecture time on housekeeping. So since the lecture hasn't started yet, class starts in what, 2 minutes, 3 minutes, something like that? I'll do a little housekeeping now, and then I'll follow up next week with an email for those of us who weren't here. But anyway, the midterm, grades aren't out yet is what I heard. Sorry to hear that. I graded them Thursday, handed it in Thursday, followed up with an email on Monday. I hear that they're going to be coming out soon. I'm hoping the grades I put down get approved and become the grades, because if so, even the lowest grade in this class was an awesome grade. So if I'm acting like I'm on cloud nine right now, I am. Because if y'all are successful, there's truly only one reason for that. And that would be me, right? Yeah. So I'm taking all the credit for your good work and your success. So, but you got a question? Whoa, I didn't know you could see a score on there. Oh, that's nice. That's nice. See, I write the exam. I write the exam, and then I give it to the administration. They're kind enough to do the computer programming where it becomes part of that, what's it called, ExamSoft? Is that what you guys use to take that? Yeah, so they set it as to whether everybody sees the same questions in the same order. I don't know what they picked there. As to whether you get to see whether it was right or wrong, I don't know what they picked there. So you were able to see as you were taking the exam whether you got the... Oh, how fun. Made it like a video game. Video games are nice. So, yeah. So, also, I plan on getting a video to you about what the right answers were and why they were the right answers. Again, just like right now, I don't like to take up class lecture time on housekeeping. So, I'll do that in a separate video, and I'll send you an email about that. Sound great? All right, looks like class starts in like 25 seconds. Any more housekeeping issues you wanted me to cover before class starts? I never like wasting lecture time on housekeeping. No? Was there any what now? Oh, no, nobody got a perfect score. and no one's ever gotten a perfect score on my exam. I hope it'll happen soon. Yeah. But BJ, you'd be the one to get it, right? If it ever happened? I bet you would. All right, we got about 10 seconds till the real lecture starts. Yes. Oh, I'd love to, but the grades I handed in haven't been approved yet. So if I were telling you those numbers, they might not be real. So, all right. Sometimes government has a job to do, but government isn't doing its job. I don't have to give you examples. You're living so many examples. Maybe you've been personally affected. If not, certainly turn on any news report on any given week, and I bet you'll hear about a government law that isn't being enforced, a government program that isn't being run right, individuals who are entitled to certain government benefits but aren't getting them. Man, oh man, what are we to do about government? And that is the topic of today's lecture. For you, my fellow lawyers, I want to empower you. I want to show you some little known ways, or little used ways, some extraordinary writs, if you will, some causes of action, if you will, that you can bring in an appropriate court of law, even here in the state of Florida, to get government to do what it is supposed to be doing. That is the gist of our lecture today. Of course, as always, before we get there, we've got a little bit of background to cover so that you can fully understand and fully use the tools that I want to teach you about. We've got to start with some basics. If I cover in too basic a way Florida's court system, you'll forgive me. But I find that even though many of you are 3Ls, some of you are 2Ls, all of you have had your first year of law school, some of you have a greater grasp on Florida's state court system than others. So to put everybody on equal footing, I'll cover that. Then I'll cover how Florida's Constitution affects the creation of Florida's state court system. I will compare and contrast Florida state court system to the federal court system. And in that way, if you struggled with the first year federal civil procedure class, maybe I can make up for a little bit of that too. So I'll cover some of those basics before I answer the ultimate question as to how I can empower you to get government to do what it's supposed to do. But before that, as always, you've been so kind to me. You've allowed me to open every class with a prayer. I thank you for that indulgence. And I begin in the name of the Father, and of the Son, and of the Holy Spirit. Amen. Our Father, who art in heaven, hallowed be thy name. Thy kingdom come, thy will be done, on earth as it is in heaven. Give us this day our daily bread, and forgive us our trespasses, as we forgive those who trespass against us. And lead us not into temptation, but deliver us from evil. Amen. Hail Mary, full of grace, the Lord is with thee. Blessed art thou among women, and blessed is the fruit of thy womb, Jesus. Holy Mary, Mother of God, pray for us sinners, now and at the hour of our death. Amen. Our Lady of Fatima, on this October 13th and on every day, pray for us. In the name of the Father, and the Son, and the Holy Spirit. Amen. So now, to recap, or to begin, how would you compare and contrast Florida's state court system to that of the federal system? How exactly does Florida state courts and judiciary work? Well, let's do a little compare and contrast with this chart, shall we? I know the font got a little small on this one, and I apologize to that. But, I'll tell you what it says, so don't worry. You've got in the yellow text there, the Supreme Court of the United States, our good friend Scotus, the U.S. Supreme Court. And on the other side, in the not yellow but white text, we see the Supreme Court of the state of Florida, Florida Supreme Court. Scotus is made up of 9 justices, as you know. To compare and contrast, the Supreme Court of Florida is made up of 7 justices. How did the Scotus justices get their job? Well, everybody knows that. They are nominated by the president and then are either confirmed by or rejected by the United States Senate. Is that how the justices of the Florida Supreme Court got their job? No, no, no. Here in Florida, the governor of the state of Florida appoints individuals to be the justices of Florida Supreme Court. Can the governor appoint just anybody? No. Can the president appoint just anybody? Almost yes. So to compare and contrast those two, the governor of the state of Florida has a lot less discretion as to who she or he might appoint. The governor of the state of Florida has to appoint someone from the list given to the governor for that seat, for that purpose, by the Judicial Nominating Commission. So these commissioners will interview and ultimately come up with the list that is submitted to Florida's governor. And Florida's governor must choose an individual that's on that list. What if Florida's governor knows that the most brilliant, the most qualified, the most wonderful future Florida Supreme Court justice is not on that list? Too bad, so sad. The governor cannot appoint that individual unless the individual made the JNC's list. How long does a Scotus justice get to be a Scotus justice? Well, at least until death, right? Or perhaps the justice might choose to retire, but a Scotus justice does not have a mandatory retirement age. Compare that to the Supreme Court of the state of Florida, where there is a mandatory retirement age in the Constitution of the state of Florida. A Supreme Court justice for the Supreme Court of Florida is not appointed for life. Instead, the justice is appointed to a 6-year term. Toward the end of that 6-year term, the voters of the state of Florida will see on their ballots a referendum, a yes or no question, which is always phrased, should Justice so-and-so of the Supreme Court of Florida remain Justice so-and-so of the Supreme Court of Florida? And you can vote yes or no. Now, it's not a contested election. If you think Justice so-and-so is great, but Justice such and such is better, you don't get to vote for Justice such and such, but you can vote against Justice so-and-so. Trivia question: how many Florida Supreme Court justices have lost their job based on a referendum? I hear silence, and that's the correct answer. Yes, none have lost their job based upon a referendum. But at least in theory, they can. And at least in theory, we, the voters of the state of Florida, could oust a Florida Supreme Court justice. Can we vote a Supreme Court of the United States justice off the bench? Can we vote out a Scotus judge? No, we cannot. So there's a difference. The Supreme Court of the United States has its jurisdiction outlined in federal law, but there is, if you will, a catch-all known as the Writ of Certiorari. If you cannot pronounce that Latin word, Certiorari, you are not alone. There's a Greenbag or law review article written about how difficult it is to pronounce that word, and as Greenbag often does in its law review articles, took a humorous approach by pulling up transcripts of Scotus justices to see what pronunciation they used. Humorously, what they found was that there wasn't a unanimous way to pronounce that word, at least among the Scotus justices of that time. Indeed, there were two justices, and I won't embarrass them by mentioning by name, who could never be found on the record to even try pronouncing the word. So if you can't pronounce certiorari, you are not alone. And the best way around it is how many practitioners get around it. You call it cert, writ of cert. The writ of certiorari is not truly a catch-all because there is a legal standard to be met for certiorari. Later in this lecture, we will be talking about the state of Florida's legal standard, or standards, plural, for certiorari. But whether it's Scotus or the Supreme Court, there are standards to be met. My point in calling it a catch-all is to say that Scotus uses it to have discretionary jurisdiction. Scotus might have jurisdiction, but choose not to exercise that jurisdiction. Stated somewhat differently, they might be able to take the case, but not desiring to take the case. So a petition for writ of cert might meet all the legal requirements and might entitle the petitioner to Supreme Court of the United States review, but the Supreme Court of the United States, for any reason at all, even an unstated reason, can say, petition for writ of cert denied. That's one side of the coin on Scotus's writ of cert power. The other side of the coin is that they have greater discretionary control over their docket, right? What if Scotus wants to have, and this has never happened, what if they want to have just a full year of antitrust cases? They literally could do that, right? They could turn down every case except antitrust, at least on the writs of cert, and give you a whole entertaining year of antitrust. Who loves antitrust? Raise your hand. Okay, we got one. Yeah. So you'd be entertained by that year. But my point is, through this discretionary writ of cert, the U.S. Supreme Court, relatively speaking, has broader jurisdiction than the Supreme Court of the state of Florida. The Supreme Court of the state of Florida has certain enumerated jurisdiction. Among the enumerations is not the power of a petition for writ of cert. Got a dramatic way of illustrating that later. We even got a clip from a newspaper article. I don't know if you remember newspapers. These are paper things that existed before the internet. Rumor has it they still exist. Anybody seen one? Well, I've got a clip of a newspaper article that will help illustrate why the Supreme Court of the state of Florida does not have certiorari jurisdiction. Indeed, it was once in Florida's Constitution, but the voters removed certiorari from the Supreme Court of Florida's enumerated jurisdiction bases. So can the Supreme Court of Florida grant a writ of certiorari? No. They can't even consider a writ of certiorari. It's not something on a technical standpoint you're even allowed to file with the Supreme Court of Florida. If you do file it, it should properly be denied for what? For lack of jurisdiction by the Supreme Court of the state of Florida. We will cover in greater detail the enumerated list of times when the Supreme Court of Florida has jurisdiction, and who knows, you might be able to stay awake until the end of that list. When does Scotus decide cases? Well, they're very methodical about that, are they not? They open their year, and I put year in quotes on the big board. Did you see that there? Because it goes from October through June. Now, I don't know about you, but that doesn't seem like an entire year to me. Who am I to complain? But anyway, Scotus works from October through June. They open their year, and the cases that they take on, they finish and they rule upon before they close up the year in June. Is that true for the Supreme Court of the state of Florida? No, it is not. Their decisions occur whenever, without any firm deadline. There isn't a deadline in the Constitution of the state of Florida. There is not a deadline in the Florida Rules of Appellate Procedure. There's not a deadline in the Florida statutes. And there are cases, not always, but there are cases that can literally take a year, year and a half, 2 years before the Florida Supreme Court rules on it. That hasn't been true in recent months, but certainly within this 4 or 5 years, past 4 or 5 years, we can point to some cases that literally took that long. So there's some differences as we compare and contrast the highest court of the land, the U.S. Supreme Court, versus the highest court of the state, the Florida Supreme Court. We'll note that our federal system and our state system both have trial courts and appellate courts. As we go a little bit deeper into Florida's state system, you'll find that sometimes a Florida court is both a trial court and an appellate court, depending on the particular case. What's a trial court and what's an appellate court? A little too basic? I'll go fast through this one. Generally speaking, a trial court is where a case starts, but not always. We'll look at some extraordinary writs. They start. In an appellate court, they're governed by the Florida Rules of Appellate Procedure from their onset. Likewise, I am your friendly neighborhood bar grievance defense attorney. I'm proud to defend my fellow lawyers, members of the Florida Bar and the District of Columbia Bar, either one, from bar grievances and ethics complaints. When I'm defending my fellow lawyer against the Florida Bar, their case begins and ends in the Florida Supreme Court. But that's not a trial court. What's a trial court? What's an appellate court? Generally speaking, a trial court is where a case is presided over by just one judge. At least the trial is. Certainly, in the federal system, there are magistrate judges where things are sometimes delegated, whether they are discovery or other types of issues. But ultimately, the trial is presided by just one judge. That's true in the federal system and in our state of Florida system. Compare that to an appeal, where, without fail, in either system, more than one judge is involved in deciding the case. A trial court is where you might have, depending on your cause of action and how you've pled, the right to a jury. A jury trial can happen. There is no right to a jury on appeal. Appellate courts don't utilize juries. In a trial court, lawyers present evidence and witnesses. Raw data, if you will, is presented to a trial court. Documents, people retelling their story, observations, testimony. The rules of evidence decide what comes in and what goes out. Compare that to the appellate court. If you file an appeal, do you get to call the witnesses to the appellate court? No. Do you get to reintroduce the evidence that wasn't admitted into evidence? No. It's a different procedure that focuses on matters of law. More details to come. Most cases begin in the trial courts. I've already pointed out at least one exception, your and my license, if the bar comes after us. The appellate court, however, does not rehear or retry the case. It's not a do-over. It's not a fresh start. It's not a mulligan. If you're a golf, anybody playing golf? What golfer can tell me what a mulligan is? Yeah, what's a mulligan? It's like, oh, did you forget about that swing? We'll swing again. An appeal is not a mulligan. So these are some typical differences between a trial and an appellate court. What courts do we have? Generally speaking, our U.S. federal court system has district courts, which, generally speaking, are trial courts. There are also the U.S. courts of appeals, which, generally speaking, do what? They do appeals, right? It's in the name. That's an easy one. Maybe we should put that on the midterm. The U.S. Supreme Court is the highest appellate court in our federal system. It is truly the court of last resort. Compare that to our state system. If you wanted to list the courts side by side, you'd put beside U.S. District Court, you'd put county and circuit court. Both primarily are trial courts. When do you start in one versus the other? I'm going to provide you with those details. Can you file an appeal with the circuit court? you might be able to do that. I'm going to provide you with those details. But generally speaking, in our state of Florida court system, the county courts and the circuit courts are trial courts. Every county has at least one county judge and at least one county courthouse. There are 67 counties in the state of Florida. There are not 67 circuits. Some counties are combined into a circuit. So a particular circuit might have one county or it might have more than one county. Next up the ladder, if you will, are our district courts of appeals. Except for the extraordinary writs that I will introduce you to and teach you how to use right here in this lecture. Generally speaking, our district courts of appeal handle what? Appeals, right? How many do we have? Right now we have 5. For the most part, they have territorial jurisdiction. There are exceptions. For example, the First District Court of Appeal hears appeals statewide from the Division of Administrative Hearings, offices of the judges of compensation claims, workers' comp claims, if you will. So there are exceptions, but generally, the 5 appellate courts have territorial jurisdiction over which cases they hear. But as I will tell you in greater detail later in this lecture, just because that ruling was decided by that appellate court for that jurisdiction, that doesn't mean its legal effect is limited to that territorial jurisdiction under Florida's system. Yes, one district court of appeal can create case law precedent that could be binding statewide under Florida's system. We'll give you some examples of that later in the lecture. Florida's Supreme Court was not intended, according to many commentators, to be the court of last resort here in the state of Florida. According to many commentators, the district courts of appeal were intended to be our courts of last resort. They reached this opinion based upon that rather strict and rather narrow enumeration of Florida Supreme Court's jurisdiction. Just because the Florida Supreme Court wants to hear a case does not mean it can. Likewise, just because Florida Supreme Court would have ruled differently doesn't mean they can take up the case. More details to come. So that's an opening summary where we compare and contrast what you already know about the federal court system and drawing upon that knowledge you have, helping you to see and understand Florida's state court system. Not Article 2 or 3, but Article 5 of Florida's Constitution is the judiciary article. Section 1 talks about courts, and I've got the words of Section 1 up here on the big board. The judicial power shall be vested in the Supreme Court, district courts of appeal, circuit courts, and county courts. The legislature shall, by general law, divide the state into appellate court districts and judicial circuits following county lines. Can one county be into appellate court districts? Can we divide it up? No, we cannot, regardless of population. So if everybody wants to live in Miami, we still can't divide Miami in half and send the North Miami appeals to one court of appeal and the South Miami appeals to another. Because Miami-Dade is a county and we can't divide up a county. So how did Florida's legislature, through its enabling statutes, divide things up? Well, I've tried to plug them in here for you. We've got one Supreme Court because that's all Florida's Constitution allows under its plain language. See it there? Right now, we've got 5 district courts of appeal. It's been that way for about 20 years. There is a proposal floating about to maybe fund a 6th district court of appeal. Will that happen? Will that not? I'm not a psychic. I'm not a person who can predict the future. If you're listening to this tomorrow, you may want to double check. But as of the past 20 years through today, there's been 5. Likewise, there's been 20 circuit courts. And as I mentioned earlier, there are 67 county courts. Our Constitution goes on to state that no other courts may be established by the state, any political subdivision, or any municipality. So there is a county court, but can I have a city court? I cannot, because no other courts may be established by the state, any political subdivision, or any municipality. What if I'm the Southwest Florida Water Management District? Can I create the Southwest Florida Water Management District Court? I cannot. There's some vocabulary to remember. If you're going to speak like a lawyer, you're going to know this vocabulary. If you hear other lawyers speaking, you're going to want to know what they are talking about. The use of the phrase circuit court in the federal system versus the Florida system is quite different. Likewise, the phrase district court in the federal system versus the Florida system is quite different. We called our 5 appellate courts, which some commentators say are intended to be the courts of last resort in our state, the district courts of appeal. See the name out there? District courts of appeal. But what did the federal system do with the word district? They used it to label their trial courts, right? We have the United States District Court for the Northern District of Florida, the United States District Court for the Middle District of Florida, the United States District Court for the Southern District of Florida. See the different uses of the word district? Likewise, when it comes to circuit. The circuit courts were our trial courts that presided over one or more territories of counties, correct? Under the Florida system? Yes. But we called our appellate courts what? The circuit courts of appeal under the federal system. So we've got to keep that vocabulary straight. Here are, for example, some of the circuit courts in our federal system. These particular circuits, 1 through 11, have territorial jurisdiction. Where are we on this map as we talk together today? We're in the sunny state of Florida. It's the 13th of October, and I was sweating out there. I was kind of wishing the sun would start dancing in the sky, but not this October 13th, I guess, because it's really hot out there, right? So there we are in the Sunshine State. That puts us squarely within what? The 11th Circuit of the federal system. Where in Florida does that court hold its non-Zoom hearings? Where does it physically hold a hearing? In Atlanta. Yes, in Atlanta, Georgia. So those are the circuit courts of appeal that have territorial jurisdiction. Compare that to our district courts of appeal here in Florida. As you can see, none of the counties are divided in half in any way, right? We've got the 1st district up there in the Panhandle. Where are we right now? I talked to you where? Orange County, Florida. Where's that on the map? Squarely within the 5th District Court of Appeal, correct? Where's Tampa? That'd be the 2nd District Court of Appeal. Where's Key West? That would be the 3rd District Court of Appeal, right? So basically you do what? You look on the map and it tells you where you file that appeal. Simple. Florida's district courts, when I talk about the United States district courts, I mentioned the U.S. District Court for the Northern District, the Middle District, and the Southern District. These are their territorial jurisdiction. Generally speaking, the Northern District is the Panhandle, the Southern District is South Florida, and the Middle District are the parts in between. But that, of course, is a generality. You see that there's a map. You see yet again, the counties are not divided in half. So you look up that county and you find out which U.S. District Court has territorial jurisdiction. Here's a map of the state of Florida and all of its counties. And here on this map, you see the circuit courts. Again, I talked to you from Orange County. It's colored in this map, the color orange. Wise choice for whoever made this map, right? It's within the 9th Circuit. And again, find your county, you look it up, or you find a good book like Florida Elements of an Action written by yours truly, where all this information is there for you to look up. You can purchase it wherever fine books are sold. So Florida's court jurisdiction in a slide, which makes me blush, I guess. But here it is, Florida court jurisdiction. We've got county courts. They'll hear misdemeanors. They'll hear civil cases currently, and you saw in the book that this is scheduled to change. right? I can't predict the future, but when I wrote the book, I put the statute, I put the date that it changes. Let's talk about today, and then you look in the book in the future. Civil cases greater than or equal to $30,000. Small claims civil cases less than or equal to $30,000. Small claims less than or equal to $8,000. Traffic, going to be held in the county court. Circuit court, felonies, family law, civil cases, $30,001 or greater. Probate, guardianship, mental health, juvenile dependency, delinquency, appeals of decisions in certain administrative, non-criminal infraction, and other types of cases. More details to come in the lecture, but not as many details as you'll find in the textbook. You should read it. District courts of appeal, all matters not directly appealable to the Supreme Court or a circuit court. Administrative appeals are provided by law. You see this little line on the side here, taking a shortcut up from county court to district court of appeal. Questions certified by the county court in a final judgment that is appealable to the circuit court and other details are in the textbook. Cases are directly appealable from the county court to the district courts of appeal. Before the recent statutory change, the vast majority of judgments of county courts were appealed to the circuit court, which sat in an appellate capacity, by which we mean it impaneled 3 judges to rule upon that appeal using the Florida Rules of Appellate Procedure. The circuit court is not an appellate court, but it impaneled an appellate panel and followed the Florida Rules of Appellate Procedure. That was how the vast majority of cases were handled until the very recent statutory amendment, which is discussed in the book. So as we talk today, only a rare few cases are appealed from county court to circuit court. Very many take the other route and get appealed to the DCA. Supreme Court, we're going to talk about its great limitations when it comes to its jurisdiction. You see a quick summary here. They have jurisdiction over death penalty cases, over decisions of district courts that invalidate a provision of the state constitution or statute, bond validations, public utility cases, validating a state statute, construction of the Florida of the U.S. Constitution, decisions affecting a class of constitutional or statutory officers, direct conflict with the Supreme Court or another district court decision, certain certified questions, or conflict certified by the district court. That's a lot of words in a little bit of slide, but I got a lot more details, much slower presented as we continue our lecture today. Article 5 talks about how our state courts are funded. Generally speaking, do you show up in court with a stack of $100 bills to hand to the presiding judge? Not if you don't want to go to jail. That's not how it's funded. All justices and justices shall be compensated by a W-2 from the state of Florida, okay? All right? Funding for the state court system, state attorney's offices, public defender's offices shall be from state revenues appropriated by general law. That's Article 5, Section 14, subsection A of the Constitution of the state of Florida. All funding for the offices of the clerks of the circuit and county courts shall be provided by adequate and appropriate filing fees. So unless you can succeed on a petition for indigency and a type of case where such a petition is allowed, in order to file your case, you're going to have to pay the filing fee. But it's not the courts and the judges that get the filing fee. It's the clerks and the clerk's office. Here in the state of Florida, the clerk of court should not be thought of as a secretary or the judge's assistant. That's what the judicial assistant is, the JA. The clerk of court here in the state of Florida is a constitutional officer who has been elected by the people of the state of Florida. Can a judge of a Florida state court give an order to be followed by a Florida clerk of the court? Well, of course, just as a judge of a state of Florida court can give an order to anyone for that individual to follow, but don't fool yourself into thinking that the clerk of court is the judge's lackey or within the judge's complete control. The concept of subsidiarity applies here. Because the clerk of court is a constitutional officer, The Constitution of the state of Florida and its statutes recognize that that officer, the clerk of court, has authority. Within the sphere of authority, the clerk of the court can do what the clerk of the court wants to do, so long as it's within that sphere of authority. The clerk of court's authority did not stem from the presiding judge. To the contrary, there are times when the presiding judge has got to jump through the hoops of the clerk of court. Sometimes that's what subsidiarity is all about. No county or municipality, except as provided elsewhere, shall be required to provide any funding for the state court system. So we've got two sources of funding. The clerks, they've got their filing fees. The justices and the judges, they've got state revenues appropriated by general law. And that brings us to our note and question to consider. Note number 2. You'll want to be on the same page as me. I'm on paper page 204. If you've got the ebook, I don't know where it is in the ebook. Note 2 reads as follows. Note how Florida's court system is funded. Does this seem adequate? Does it? Who can help us with that? How about our lead counsel? Yeah. Now, I got a beautiful outline from more than one lead counsel, and I've got it on the website. So click on that, enjoy it. Would those lead counsel want to identify themselves? Would you raise your hand if you're involved in that beautiful outline that I've got on the website? Thank you. Thank you. Thank you. Thank you. Did I miss anybody? Did I miss anybody? Yeah, applause is in order. Well done. Well done. Matter of fact, let's just read the outline and go home. I'll see you tomorrow. Just kidding. Just kidding. Yeah, but you could almost do that. So it was really well done. It was really well done. Now, were there any lead counsel, in addition to the outline or instead of the outline, that want to get picked on all day long? Get raise your hand. Hey, all right. Got one? Got one? Oh, man, you're really about to get picked on, my friend. And I know when you sign up for lead counsel, you put down what Ken McGinley, that's me, call you. What can I call you? Anthony. All right. Appreciate it, Anthony. I'm Patrick. Good to meet you, sir. Mind if I pick on you? Sure. All right, because you can take it. I know you can. And the first question is, you've noted how Florida's court system is funded. Does this seem adequate, Anthony? What do you think? Seems fine to you. All right. Anybody disagree? Well, what about the next question, Anthony? It says, what can Florida's court system do if funding proves inadequate in any given year?
I didn't see much behind that. Basically, saying, if you look at subsection C, it says you shall be required for no county municipality should be required to provide any funding for the state court system. So we have the office of defenders office for court appointed counsel or the officers of the court, so they can't really do much.
Anthony, you're correct. You're correct, sir. They really can't do much. So the clerk of the courts, they collect filing fees, but they collect a filing fee based on a statutory schedule. So if the clerk finds, I'm getting $400 for the filing fee, but we're doing $500 worth of work, what's the clerk of court do? I guess through an organization of clerks of court, tries to get the attention of Florida's legislature in hopes that they might fix that law. But they can't just change the fee schedule. They can't do that. Likewise with the judges, the state attorney's office. Maybe they're budgeted. Maybe they're understaffed. They can't directly do something about it. Think about the judges themselves. What if you're got 3 judges in a particular county and you really need 9? I guess you can, what? I don't know. You're familiar, of course, Anthony, that the judges have ethics rules they've got to follow, right? So although we have elected judges here in the state of Florida when it comes to county and circuits, that's different than our federal system where the federal judges are appointed by the president, confirmed by the Senate. So although they might have run for election and might soon run for re-election, and that election might be partisan, other than that partisanship, they're supposed to act apolitical. They're supposed to act neutral. That's a rough summary of the rules of judicial conduct that apply to Florida state court judges. So they really can't hire a lobbyist to go up to Tallahassee and try to lobby for more money. Now, they can appear before the Judiciary Committee, especially if the committee is the one that initiates them to sit in the chair and ask some questions. And then they can try to explain in a very nonpartisan way the fact that there's just 3 of us and we need 9 and we're overworked over here. Help! But of course, they have to maintain the demeanor of their judicial office while doing so, right? Because unlike us lawyers who have to not be unethical, judges have to avoid the appearance of impropriety. We can't be improper as lawyers, but judges have to avoid the appearance of impropriety. In other words, they weren't improper, but they looked improper, so they got in trouble for failing to avoid the appearance of impropriety. So if you're on this witness stand in Tallahassee, where at least a local website or a local newspaper might cover your testimony, you got to be careful not to lose your job in the process by violating some of those judicial ethics rules. So what happens if the judiciary doesn't have enough money? Well, basically, they're just out of luck, right? Is that a good, fair summary, Anthony? Out of luck. So write that in as the answer here, out of luck. I don't know if you had that in the outline. Is it too late to put that in the outline? Out of luck. No? Okay. All right. So I just thought that was something important to think about. Let's look at the jurisdiction of Florida's 5 district courts of appeal. This is Article 5, Section 4 of Florida's Constitution here on the big board. And again, sorry that the fonts get a little small in this particular lecture. 3 judges shall consider each case. So that's in the Constitution. The Florida Rules of Appellate Procedure, after 3 judges consider the case, give you the opportunity to ask for rehearing en banc. That's E-N space B-A-N-C, a Latin term meaning the full court. So all the judges then might reconsider the motion for rehearing, or they might not. They have discretion by following the rules set in the Florida Rules of Appellate Procedure as to whether or not to grant a petition for en banc. But notice somebody's got to ask for it, and it happens after the case has been decided. It happens as part of a motion for rehearing. Article 5, Section 4, subsection B tells us that the 5 district courts of appeal in the state of Florida's court system have jurisdiction to hear appeals from final judgments or orders of trial courts, including those entered on review of administrative action. If that order entered on review of administrative action is not directly appealable to the Supreme Court or Circuit Court. Where do I go to answer the question as to whether or not this order is one of those? I go to Florida Statutes Chapter 120, which is Florida's Administrative Procedures Act. That will help answer the question. What about an order that's not the last order in the case? The last order in the trial court's case is generally called what? Judgment. Typically, that's an act of finality. That is the last step in a case. Is often labeled a final judgment, I guess just to rub it in for whoever lost, because a judgment is final, right? And there can be more than one judgment arising from a particular case. But usually, the judgment ends judicial labor, at least to the party that is mentioned in and is the subject of the judgment. So it might be final judgment in favor of defendant X, or final judgment in favor of plaintiff 1, or final judgment in favor of defendant B, what have you. In addition to judgments and those types of final orders, other orders come out along the way, right? You have some procedural skirmishes. You try to quash a subpoena. You try to compel a better answer to the interrogatories. You try to overcome an assertion of privilege in a request for production of documents and things. Trial judges will resolve those and enter an order. But typically, those orders are not the end of the case. For the most part, those orders are not appealable. But the Florida Rules of Appellate Procedure will give you a list of appealable final orders. One way to describe these orders that aren't judgments, that aren't the last word in the case, is to call them an interlocutory order. You see the word there used in Florida's Constitution, interlocutory. The district courts of appeal may review interlocutory orders in such cases to the extent provided by rules adopted by the Supreme Court of the state of Florida. We call those rules the Florida Rules of Appellate Procedure, which sometimes make reference to the Florida Rules of General Practice, which are called, I have a long name, Florida Rules of General Practice and Judicial Administration, I believe is the full name of that particular rule set. There aren't a lot of references in the Florida Rules of Appellate Procedure to that longer named rule set, but there are some. So you're best to check both. A district court of appeal or any judge thereof may issue writs according to Article 5, Section 4, subsection B, subsection 3. That's 5.4b3. Are you keeping up with me here? 5.4b3. You sank my battleship. Just kidding. It's on the bottom of the slide. A district court of appeal or any judge thereafter may issue writs. And we're going to cover those extraordinary writs in this lecture. What about the circuit courts? Their jurisdiction is in Article 5, Section 5, subsection B. Original jurisdiction not vested in the county court is part of the jurisdiction of the circuit court. They shall have the power to issue writs. Do you note the overlap? They both had the power to issue writs. That brings us back to that enticing question I started the lecture with. What about government that's not doing its job? How do we, as lawyers, compel government to do its job? One of the ways is through these extraordinary writs that we're going to talk about. So note well that so far, our Constitution says there's a power to issue writs not only by the circuit courts, but also by the district courts of appeal. County courts. There shall be one or more judges for each county court as prescribed by general law. The county court shall exercise the jurisdiction prescribed by general law. Specialized divisions, all courts, except the Supreme Court of the state of Florida, may sit in divisions, as may be established by general law. A circuit or county court may hold civil and criminal trials and hearings in any place within the territorial jurisdiction of the court as designated by that chief judge of that particular circuit. Again, subsidiarity. We see that the chief judge is a constitutional officer and has constitutional powers. Supreme Court is discussed in Article 5, Section 3. As we noted earlier, it consists of 7 justices. That's in the Constitution. What if you want to do some court packing? What if you're like, oh man, I don't like, from a political standpoint, what I'm hearing out of the Supreme Court of the state of Florida, I'm gonna change it to 21 justices. So those original 7, they can rule against me all they want. Can't do court packing without changing the Constitution here in the state of Florida, right? Because Florida Supreme Court is protected from court packing under Article 5, Section 3, subsection A. Do I need all 7 justices? What if somebody's sick? What if there's a hurricane? We have those here in Florida. What if there's a natural disaster? 5 justices constitute a quorum. The concurrence of 4 justices is required to render a decision. So whether there's 5 or 6 or 7 that are sitting, you got to get 4 votes to win. When recusals for cause would prohibit the court from convening because of the requirements of this section, judges may be assigned to temporary duty and substitute for the excluded or non-present judges. So you too might be called up to preside over a Supreme Court of Florida case. I'd love to see you there. I'll watch that on the Zoom. That'd be cool. What about attorneys? Under Article 5, Section 10, or sorry, Section 15, the Supreme Court of the state of Florida has exclusive jurisdiction to regulate us, persons admitted to practice law, and to discipline us, by which we mean sanctions, take away our license, disbarment, unpaid vacations, also called suspension. That's solely within the Supreme Court of the state of Florida. That's why on a daily basis I get to practice in front of the Supreme Court of the state of Florida, because as I defend my fellow lawyers, my cases begin and end there. When it comes to the actual evidentiary hearing, Supreme Court of the State of Florida will appoint a referee to physically hold the trial. But ultimately, that referee's report, it's not called an order, it's called a report, goes to the Supreme Court of Florida, and Supreme Court of Florida who decides the case. That's true for us attorneys. Now, what about the practice of law? Who can practice law? Let me take a couple of hypotheticals here. Anthony, you're on the spot, man. I respect that and I appreciate that. Got two crazy hypotheticals for you here, Anthony. Let me ask you these questions. Here's the long fact pattern that goes with the hypothetical. You see it on the big board. Johnny, I had to pick a name. My middle name's John, so I picked Johnny. Johnny never went to law school. I did, by the way, I went to law school. But Johnny never went to law school. Johnny wants to call himself a patent agent. But there's one problem. Johnny flunked the patent bar exam given by the United States Patent and Trademark Office. Oops. Sorry, Johnny. But the United States Patent and Trademark Office later hire him as a patent examiner. That's not a lawyer. That's an employee of the patent office, helping to process those patent applications, helping to make those decisions. 4 years later, after holding that patent examiner office with the USPTO job for 4 years, Johnny quits, and then he follows the rules for former examiners that you can find in 37 Code of Federal Regulations, section 11.8. By following those rules, Johnny obtains the title of patent agent. Coolest part is this title, patent agent, that's the title Johnny would have earned if he hadn't flunked the USPTO's patent bar exam 4 years earlier. So he flunked the exam, he never retook it or passed it, but he still got the same title. Cool for Johnny, right? Now with this title on his business card and on his sign and on his website, he comes down here to the Sunshine State. He's not working for anybody. He's a sole practitioner. He opens up an office. He hangs up that sign. He hands out those business cards. They all say patent agent. He's advertising. He's giving legal advice. He admits it. He's giving legal advice to patent applicants. He's drafting up patent applications. He's not just typing what he hears. He's making decisions. He's giving clients advice. And he's processing and drafting and being creative and doing the work to draft up the patent applications. He meets with the patent examiners like he used to be. He argues with them. He advocates on behalf of his client if they happen to deny the patent application. Anthony, you heard all the stuff Johnny's doing here, man. Here's my question to you, sir. Can the Florida bar shut down Johnny's office? Anthony says no. Anthony says no. Who's going to raise their hand and say, I agree with Anthony? No, Florida bar can't do it. Look at that. If you want to raise your hand, you'll be right. Yes, you're correct, sir. The Florida bar cannot shut down Johnny's office. Is that because Johnny's not practicing law? Well, we could debate that one, but it sounds like the practice law to me. Doesn't it sound like the practice law to you? Sure does sound like the practice law to me. What about UPL? Some people say UPL stands for the unlicensed practice of law. I suggest the better definition of the term UPL is the unauthorized practice of law. Unauthorized practice of law. Why do I prefer unauthorized practice of law? Because of examples like Johnny here, you don't need a license to practice some kinds of law, but you do need authorization. See the citation to the Code of Federal Regulation, the CFR, 37 CFR section 11, cited right here in this example? That gave Johnny authorization to do what? To do everything Johnny's doing. Does it give Johnny authorization to defend someone against a DUI in state court? No, it doesn't. Does it give Johnny authorization to become a member of the bar of the United States Supreme Court? No, it doesn't. But look at all the things it does authorize him to do. Those look like the practice of law. I would suggest the reason they look like the practice of law is because they are the practice of law. That's my suggestion to you. But he is authorized to do these things by federal law. What's the supremacy clause of the United States Constitution make supreme? The supremacy clause of the U.S. Constitution makes federal law supreme. This federal law and the Code of Federal Regulations authorize Johnny to do what he does. So the Florida bar can't shut him down despite Florida's Constitution, despite Article 5, Section 15, saying that the Supreme Court of the state of Florida has exclusive jurisdiction over those who practice law in the state of Florida. That might be what the state's Constitution says, but thanks to the Supremacy Clause in the U.S. Constitution, when the Code of Federal Regulations authorizes this type of behavior, that preempts even our highest expression of state law, even our state's Constitution. You had a question, sir?
So my only question is, like, there's a line there, though, with legal advice, right?
Is there?
You can give legal advice pertaining to the area that
He needs authorization. So if someone comes to him with a DUI, someone comes to him with domestic violence, someone comes to him with the need for a guardianship under state law, the Code of Federal Regulations didn't authorize Johnny to do that. But look at all the things that the Code of Federal Regulations did authorize Johnny to do. And you can try to pretend that the things the Code of Federal Regulations authorized him to do are not the practice of law. You can try to pretend that all day, but let's be realistic about it. Is this not the practice of law? Client comes to you, doesn't know what to do, doesn't know what the law is. Johnny gives them advice. Johnny suggests a path. Johnny does the drafting. Johnny meets with the government agency. Johnny is the advocate. Johnny argues on behalf of the drafting that Johnny did. You could try to tell me that's not the practice of law, and I will do my best not to laugh at you, because it is, in my opinion. But this part's not a matter of opinion. It's not a matter of opinion that that's what the CFR authorized Johnny to do. That's true. That's not opinion. This other part is not a matter of opinion. The Supremacy Clause of the United States Constitution means that the Code of Federal Regulations and its authorization of Johnny's behavior preempts even our state's Constitution. That's also not a matter of opinion. That's also true. So we can get into the nitty-gritty about whether or not this is really the practice of law, but the outcome is going to be the same. Johnny's allowed to do it.
No, I'm not saying whether what he's doing here
Yeah.
is a problem, but I'm saying that the Code of Federal Regulations only protects him so far.
Okay. What if I amend the Code of Federal Regulations and I say that you're authorized under this code to go into Florida state courts and do anything a licensed Florida attorney can do? That's not what the Code of Federal Regulations says. Probably will never be what the Code of Federal Regulations says, but hypothetically, let's pretend somebody changes the Code of Federal Regulations and that's what it says. Now, can I do that?
Assuming there is some other conflicting constitutional requirement, yes.
Correct.
He will be protected by the federal.
Right. That's my point exactly. And to rub in my point, Anthony, stay with me now. That was Johnny. This is Sally. Sally never went to law school or college. She dropped out of high school, but good for her. She then earned her general equivalency diploma, her GED. After meeting the requirements of the United States Internal Revenue Service, she's given the title enrolled agent. Anybody ever work with an enrolled agent? Brilliant people, right? Brilliant people. As an enrolled agent, Sally moves to Florida, opens her own office, and gives tax advice. She opens up the United States Tax Code, which is a law. She interprets that law and advises her clients as to what it means, how to apply it, what to do to comply with it, and what not to do to avoid violating it. She does this for the purpose of helping them minimize their future tax bills without violating the law. When clients are audited, Sally meets with the IRS without the client present on behalf of the client and argues the client's case as the client's advocate. If that doesn't go well, she appeals within the IRS any of her arguments that are rejected, and she handles that appeal. If that fails, she uses her membership in the United States Tax Court, which is one of the district courts that has more than just territorial jurisdiction within our federal system. She's a member of the United States Tax Court, and she will file a complaint, and she will sue the IRS on her client's behalf. She's doing all this within the state of Florida, and she's not licensed to practice law here. Anthony, can the Florida bar shut down Sally's office?
No.
Who says the Florida bar cannot shut down Sally's office? Raise your hand. Come on, if you want to be right, raise your hand. You're correct, sir. And so are all of you that have raised your hand. They cannot. They cannot. Why again? Because she is authorized. Federal law in the IRS tax code authorized her to be an enrolled agent and to do all those things. Using that authorization, she passed the exam and became a member of the United States Tax Court. Rule 200 of the United States Tax Court invites enrolled agents and other non-lawyers and other individuals who have not been licensed to practice law to take that exam and potentially pass it and then practice before their court, just like a lawyer could do. So she has authorization from the United States Internal Revenue Code, and she has authorization from the Rules of Procedure of the United States Tax Court. Both of those preempt even the highest expression of state law here in the state of Florida. They preempt Florida's Constitution. I'm going to go over with you case law precedent in Florida state courts. By so doing, it's going to illustrate that sometimes one district court of appeal, despite having territorial jurisdiction that is less than the entire state of Florida, could create case law precedent that is binding upon the entire state. But before I do that, y'all need a break. I'm sorry that's going to be a short one, but if it's not a short one, then you might miss out on playing everyone's favorite game show called Name That Writ. And I know you're dying to play. So let's take just a 4-minute break. I know that's considerably shorter than usual. I'll see you in 4 minutes. 4 minutes. 4 minutes. And hey, do me a favor, if you haven't signed in on the attendance sheet, please do so. And that's not just true today, that's true every day, please. Thank you. Oh, no, sorry. Yeah, what's going on? This one is gone, and then this one is like, I don't know. So I don't want to embarrass them. Yeah, I mean, Jim, sorry about that. No, it's okay. Yeah. No, appreciate it. Yeah. Even if I could see it, it's still off.
PlayStation and whatnot, yeah, internet, so I could put two data there, I'd be good. For yeah, but you also be closer to the satellites too.
Right.
What? Only thing is,
Hey, welcome back. Sorry about the short break, but some of you might miss this part because you already covered this part. I know you took some legal research and writing classes in your first year. Undoubtedly, they covered this, but I just want to go over it one more time because sometimes either it wasn't covered or it was covered and you forgot it. This is stuff you got to know if you're going to practice within Florida state court system. It has to do with case law, precedent, and Florida state courts. Here's the problem, if I can sum it up in this way. Some case law precedent is called controlling because its decision is enforced as the only permissible outcome. So case law precedent that has a decision that is enforced as the only permissible outcome, we call that type of precedent controlling. Other case law precedent is called persuasive. What's the difference? It's persuasive because it presents one possible outcome for the court to consider. The same case that is controlling in one court might merely be persuasive in another court. That's the problem. What's the solution? The solution under Florida system is for you, my fellow lawyer, to understand the hierarchy of Florida state courts so that you know when you have found controlling precedent and not just persuasive precedent. You know the basics at the bottom of the pyramid, or lowest in rank, if you will, are 67 county courts. Above that in the pyramid, 20 circuit courts. We move up the pyramid, there's fewer now. Used to be 67, then there was 20, now there's 5. So we're moving up the pyramid, 5 district courts of appeal. And then finally at the summit of the pyramid, just 1 Supreme Court of Florida. We know that the various circuit courts have territorial jurisdiction over their county. So if a circuit court were to sit in its appellate capacity and render an opinion in its appellate capacity, that would be binding case law precedent for all the other counties within that circuit. Likewise, if a district court of appeal, which is always sitting in an appellate capacity, rules upon a decision, clearly that is binding case law precedent. It is controlling, not persuasive, when it comes to all the counties and circuits within the territorial jurisdiction of that district court of appeal. But as you know from your prior studies, if this is a decision on an issue of first impression upon which the other district courts of appeal are silent, then unless and until those other district courts of appeal rule otherwise, then the ruling of the one district court of appeal is controlling precedent statewide. So what then are the sources of controlling precedent? They are 2. First, on the one hand, prior case decisions of your appellate court, meaning the one with the territorial power to review and reverse the decisions of the court that you happen to be in. The other source of controlling precedent under our Florida court system are prior case decisions of another appellate court of equal rank to your appellate court, but only when your appellate court has not ruled on that particular issue. You see how that works? Why does that seem so upside down? But that's how it works, whether it seems upside down or not. Here's a real world example for you. And again, I know I'm repeating what you already learned in your first year of law school. But for those of you who didn't quite get it, maybe this helps. For those of you who got it but forgot it, here's the refresher. Real world example number 1, you're researching whether your corporate client's in-house investigation report is subject to discovery by the opposing side. Your client's suit is pending before the 9th Judicial Circuit, right? That's the one that presides over us here in Orange County. You find case law precedent from the 5th District Court of Appeal, holding that such a report is indeed subject to discovery. And you know that the 5th District has territorial jurisdiction over the 9th Circuit. Is this controlling precedent? Well, that's a no-brainer. The answer there is yes. If we look at the map, we see that the 5th District Court of Appeal has territorial jurisdiction to review and reverse orders of the 9th Judicial Circuit Court. It's the 9th Judicial Circuit Court where our trial case is pending. Therefore, that makes this precedent controlling. You remember the map. There's Orange County in orange. It's in the 9th Circuit. It's right there in the center of Florida. That's why we call ourselves Central Florida. Did you ever notice that? And that's also within the territorial jurisdiction of the 5th District Court of Appeal. So that real-world example was an easy one. Let's look at the second real-world example. Was this harder? Did you not catch this when you studied it in your first year of law school? Same facts as example 1, except this time there is no precedent from the 5th District Court of Appeal. It's not that they ruled against or in favor. They just have never ruled on this issue. There's no precedent from the 5th DCA. Instead, the 1st District Court of Appeal is the only district court of appeal within the state of Florida to have ever ruled on this Florida state law issue. Is the 1st DCA's decision controlling precedent before the 9th Judicial Circuit Court? Now remember, the 9th Circuit was not within the territorial jurisdiction of the 1st DCA. It was in the territorial jurisdiction of the 5th DCA. So was the 1st DCA's precedent merely persuasive, or was it also controlling? The answer is that it's controlling. The 1st DCA's ruling is binding precedent statewide. How did that happen? It happened this way. We're before the 9th Judicial Circuit Court, but my appellate court is the 5th DCA. The 5th DCA has never ruled on this issue, but the 1st DCA has. So that invokes the second of the 2 sources of controlling precedent here in the Florida state court system that we discussed. Remember, there were 2 sources of controlling precedent. Now maybe it doesn't seem so upside down, right? Now you can see that one source is prior case decisions of your appellate court, meaning the one with the power to review and reverse the decisions of the court you're in this hypothetical, meaning the 5th DCA. But there was also a second source of controlling precedent. Prior case decisions of another appellate court of equal rank, 1st DCA, 2nd DCA, 3rd DCA, 4th DCA, 5th DCA, all equal rank in that pyramid of courts that we looked at. Prior case decisions of another appellate court of equal rank, but only when your appellate court has not ruled. Under our hypothetical here, our appellate court has not ruled. Therefore, the 1st DCA is controlling for this issue in a trial court that exists in the 5th DCA. Interesting, interesting. But you knew that, right? How many of you can honestly say, yeah, I remember that. Thank you. Okay, 2, 3. All right, so maybe it was worth going over. So let's keep going. You know, McGinley, he's always pushing his luck. You have a question. I thought you were saying, yeah, I knew that. You did know that, but you also have a question. Okay, I don't want to do you wrong. Oh man, you're jumping ahead. That's slide number 3 over here. No, I see where you're going. I was going there too. Great minds think alike. Let me do this slide, see if it answers your question, which I believe it does. And if it's not an answer to your question, then I will answer your question. Okay. Yes, but here's real world example number 3, which I think is exactly where you're going, sir. Here we go. Same facts as before, but this time there are 2 appellate decisions on point. One's from the 1st DCA and one's from the 5th DCA. 1st DCA says yes, and the 5th DCA says no. Which, if any, is controlling precedent before the 9th Judicial Circuit Court? Answer is the 5th DCA. Why is that? The 5th DCA is the appellate court with the power to review and reverse the decisions of the 9th Judicial Circuit Court. Remember the map? The map said the territorial jurisdiction of the 5th DCA included the 9th Circuit. That means the 9th Circuit must do as the 5th DCA requires when it comes to appellate case law precedent. Now, can I cite to the 1st DCA's opinion? Well, I can. But it is persuasive precedent. I must also cite to the 5th DCA's opinion because that opinion is controlling precedent. Can the trial court follow the persuasive precedent instead of the controlling precedent? Not without getting reversed. Not without, if you will, breaking the rules. Maybe the trial court thinks it's better than the appellate court. Subsidiarity says it can enter an order following the persuasive precedent of the first DCA. You would then appeal that to the fifth DCA, and presumably you would win that appeal because presumably the fifth DCA has already ruled on that issue, and under stare decisis would remain true to that prior decision, presumably. But of course, subsidiarity says that the fifth DCA might reverse itself. It might be persuaded by the first DCA's persuasive precedent. So did that answer your question, this hypothetical? No, okay. I shouldn't have shot you down. Please give me your question.
So let's say we're in the fifth and we're in the territorial jurisdiction of the fifth DCA.
Okay, I'm the same facts as before. I'm in the territorial jurisdiction of the fifth DCA.
Fifth DCA has another ruling with first and third.
Yeah.
Can we pick either one? Or?
Is that my next slide? That's my next slide. Great minds think alike. Let me see if this slide answers the question. And again, if it doesn't, I swear to you, I'm going to answer it if it doesn't. All right, real world example number 4. Same facts as before, but this time the 2 appellate decisions on point come from these 2 courts. One from the first DCA and one from the fourth DCA. So, sir, we're thinking alike, right? This one actually is your question. Yes, okay. So same facts as before, but this time the 2 appellate decisions on point come from the first DCA and the fourth DCA. Remember, the territorial jurisdiction of my trial court was the 5th DCA, but we got nothing from the 5th DCA. What we do have is one from the first and one from the fourth. The first says yes and the fourth says no. Which, if any, that's the loaded part of the question, if any. Which, if any, is controlling precedent before the 9th Judicial Circuit Court? Well, we know the 9th Judicial Circuit Court is in the territorial jurisdiction of the 5th. We know the 5th has remained silent. The first says one thing, the fourth says the other. The answer is neither are controlling precedent. Both remain persuasive precedent. Best practices, I suggest, would be to share both opinions with the 9th Judicial Circuit Court and then argue which one is better than the other. I call that best practice because when it comes to the rules regulating the Florida bar, you're obliged to point out controlling precedent to your court. You're not obliged to point out persuasive precedent. Persuasive things come from anywhere. You might even pull up another state's decision. You might pull up a law review decision. You might pull up a case law textbook. You're not required to spend 20 hours in court going over anything. Well, in New Zealand in 1743, Your Honor, they ruled this way. You're not required to do that. You are required to cite to binding, controlling case law precedent. So here, I would suggest best practices would be to cite to both cases and to argue which one is better. Another option might be just bring up the case you like and see whether opposing counsel brings up the other one. That's another option. But what is the trial court to do? To make up its own mind. There isn't any controlling precedent under this hypothetical. Did I answer your question, sir?
100%.
Ah, yes. Every dog has his day. All right, okay. All right. Jurisdiction of the Supreme Court of the state of Florida. Let's see who can stay awake through this one. We already talked about how it's not as broad as Scotus because it doesn't have that, what? Oh, someone can pronounce it. Well done, yes. Doesn't have the ability to grant or deny petition for writ of certiorari. Yeah. What can it do? It can hear appeals from final judgments in trial courts opposing the death penalty. From decisions of district courts of appeal declaring invalid a state statute or provision of the state constitution. Those are mandatory. It's got to hear the death penalty, it says shall. And it's got to hear the case if we said the state statute is unconstitutional. What if instead we said the state statute was constitutional? Now it's not mandatory. Now it's not shall. Now it's may. So the Supreme Court of the state of Florida has to get involved if by the time the case comes to it, the result is this statute from Florida's legislature is unconstitutional. If by the time the case comes to Florida Supreme Court, the status is the statute is constitutional, then they may, but they don't have to, take jurisdiction. If there's a law that says so, they can hear appeals from final judgments entered in proceedings from the validation of bonds, and there is such a law, and shall review action of statewide agencies related to rates of service of utilities providing electric, gas, or telephone service. May review any decision of a district court of appeal that expressly declares valid a state statute. That's what I was mentioning earlier. If they say, hey, that's unconstitutional, then the Florida Supreme Court has to take the case. If they say, hey, that's constitutional, then the Florida Supreme Court may, but doesn't have to, take the case. Or that expressly affects a class of constitutional or state officers, or that expressly and directly conflicts with the decision of another district court of appeal or of the Supreme Court on the same question of law. Remember hypothetical number 4, which was finally your question? We were in front of the territorial jurisdiction of the 5th DCA, but the 5th had no controlling precedent. There was persuasive precedent from the 1st that said yes, and persuasive precedent from the 4th that said no. While either one of those cases is still pending, while they're 30 days or less old, either one of those parties could have asked the Supreme Court of the state of Florida to take the case and decide the case. This would have been within conflict jurisdiction of the Supreme Court of Florida. Note, however, that you and I can't ask. It's got to be the parties to one of those two cases. Note the deadline. If they don't see the conflict within the 30 days and don't point it out and don't ask for review by the Supreme Court of Florida within that deadline, too bad, so sad. No jurisdiction. What if it turns out later everybody's in a fluster, in a hullabaloo, in a hubbub, looking for a word here that shows everybody just scratching their heads, running around all over the state? What do we do? Part of the state says this is the law. The other part of the state says that's the law. What do we do? What do we do? Well, you don't go to the Supreme Court of the state of Florida. They don't have jurisdiction. You might try passing a law. What? In a democracy, we can make law by voting? Yes, we can, fellow lawyers. Here in law school, we're so caught up in the case law precedent, sometimes we forget that a democracy's purpose was to have our elected officials do the investigation, have the debate, hear from their constituencies, and vote. So whether it means amending the Constitution or passing a state statute, that's one way to resolve these conflicts. The Supreme Court of Florida has jurisdiction review any decision of District Court of Appeal that passes upon a question certified to it to be of great public importance. So the DCA says, you know, you lose this case, but I recognize, I being the first DCA, how important this is. I'm going to certify this as great public importance. That gives Supreme Court of Florida the opportunity to take the case. What's the opposite of that? How does a District Court of Appeal in Florida do the opposite? How does it make sure this case never gets appealed again? With 3 words. They're Latin. Per curiam affirmed. They resolve your case with an opinion that says just those 3 words, per curiam affirmed, or a PCA, if you will. If you get a PCA, per curiam affirmed, that's it. You cannot appeal further to the Supreme Court of Florida. The Supreme Court of Florida may review any order or judgment of a trial court certified by the DCA to be of great public importance or to have a great effect on the proper administration of justice throughout the state and certified to require immediate resolution by the Supreme Court. Query, you get that PCA. All the opinion says is per curiam affirmed. Can the Supreme Court of Florida review this decision? Anthony? Says no. Everyone else agree? That's right. The answer is no. There's nothing you can do with the PCA except call your client and tell them how stupid those judges are. Oh, those stupid judges. Jurisdiction of the Supreme Court may review a question of law certified by the Supreme Court of the United States or United States Court of Appeals, which is determinative of the cause and for which there is no controlling precedent in the Supreme Court of Florida. Subsidiarity in action, ladies and gentlemen. We're in the federal system, but nobody's resolved this state law question that happens to be properly within the jurisdiction of a federal court. Federal court could say, well, supremacy clause, I'm going to decide what the law of the state of Florida is. But subsidiarity says that instead there can be comity, C-O-M-I-T-Y. Again, sorry about the jaw. I hope I'm not mispronouncing it. I'm not trying to say comedy. Comedy is what I do up here for 2 hours once a week. But instead, I'm talking about comity, C-O-M-I-T-Y. Comity is the federal system having the power, but relinquishing that power. Comity says that either the Supreme Court of the United States or the United States Courts of Appeal can put their case on hold, send it over to the Supreme Court of Florida, and let the Supreme Court of Florida decide what Florida law says. And then having that opinion, take up the case and finish the case in the federal system using that state law precedent. The Supreme Court shall, when requested by the Attorney General, render an advisory opinion. We talked about this when we talked about the executive branch. And you remember how you determine whether or not you can get an advisory opinion for your client. You ask your client for their ID. You pull up the website that names the Attorney General of the state of Florida. You compare the website to the ID. Am I sitting in front of the Attorney General of the state of Florida? If I'm not, then I can't get an advisory opinion, not even from the Supreme Court of the state of Florida. The Supreme Court may issue writs of prohibition and all writs necessary to the complete exercise of its jurisdiction. It may issue writs of mandamus and quo warranto to state officers and state agencies. It may, or as justice, or a single justice may, issue writs of habeas corpus, returnable before the Supreme Court or any justice, a district court of appeal, or any judge thereof, or any circuit court. Anybody here understand what I'm talking about? Don't worry, I'm about to beat your head over it. Beat it over your head. I'm going to rub it in and teach it well by playing everybody's favorite game show, Name That Writ. Now, Name That Writ is everybody's favorite game show because in the game show Name That Writ, McGinley comes up with one preposterous hypothetical after another, all illustrating the government not doing what it's supposed to do. We began this lecture with that problem. How do we lawyers compel the government to do what it is supposed to do? So as not to get personal or single anyone out, I've come up with the craziest sounding hypotheticals that couldn't possibly be true, and none of them are. But all of them illustrate the use of one of these extraordinary writs. And by empowering you to use these extraordinary writs, you can do what your client needs done. You can force the government to spring into action and make a government do what it is supposed to do. Let's take a look at these extraordinary writs. Supreme Court can issue writs of prohibition, mandamus, quo warranto to state officers and state agencies, and the habeas corpus. Remember, and this query helps you remember what we've already talked about. Supreme Court of the United States can and sometimes does grant petitions for writ of certiorari. Florida's 5 district courts of appeal can grant petitions for writ of certiorari. Even Florida's 67 circuit courts. Oh, sorry, got that number wrong. But striking the number. Even Florida's circuit courts, when sitting in their appellate capacity, can grant a writ of certiorari. My question is this: can the Supreme Court of Florida grant a writ of certiorari? Anthony, I'm picking on you all day long. Can it? No, says Anthony. Raise your hand if you agree with Anthony, which is always the right thing to do, ladies and gentlemen. Yes, you are correct in saying that the Supreme Court of Florida cannot grant a writ of certiorari. Why is it that the Supreme Court of Florida cannot grant a petition for writ of certiorari? Why did the people of the state of Florida amend their own constitution to deny their highest court the ability to grant this important writ? The answer can be summarized as follows: because corruption has its price. The Supreme Court of Florida no longer has authority to grant or deny a petition of writ of certiorari because corruption has its price. I'm not talking about the current court. There's nothing corrupt about the current court. Of course, you know from your readings that I'm talking about the historical court. I'm talking about the fact that in 1975, according to historians such as William Levesque, I'm quoting here from what used to be called the St. Pete Times. That newspaper has changed its name. This is an article that ran on October 28th, 2001. It was on page A14. It was called Path to Impeachment Always Thorny. William Levesque spent more than 30 years reporting upon Florida politics and was a noted reporter. Also, William Levesque wrote history books, which are well respected. William Levesque, here in this Path to Impeachment Always Thorny, 2001 article writes, quote, in 1975, Supreme Court Justices Hal Deckel and David McCain resigned while being investigated by a Florida House of Representatives impeachment committee on separate charges, including allegations that both pulled strings to help friends. Justice McCain was accused of lobbying a lower court to overturn the bribery conviction of a political supporter. He resigned the day before the House, quote, almost certainly would have impeached him, end quote. To continue Mr. Levesque's quote, the case, which included evidence McCain may have accepted a $10,000 bribe, ultimately got him disbarred. Here's an article from the New York Times. A president once called it the failing New York Times. But this New York Times article was written before it was failing, right? This is from around the nation. It says, let's see, what's the date of this article? September 27th, 1982. Ex-Florida court justice accused in drug case, according to the New York Times, September 1982. Fort Pierce, September 26th. David L. McCain, who was forced to resign from the Florida Supreme Court in 1975, was arrested Saturday on charges of conspiring to import and distribute more than 10,000 pounds of marijuana, the authorities said. Sounds like more than personal use, maybe? I don't do marijuana, but 10,000 pounds sounds like more than personal use. To continue quoting from the article, quote, Mr. McCain, 51 years old, was arrested at his home in the Lakewood Park section of Fort Pierce and released on $200,000 bond Saturday night. Law enforcement agents said Mr. McCain helped arrange marijuana smuggling operations in Louisiana from May to October of last year. Mr. McCain was appointed to the state Supreme Court in 1970 by Governor Claude Kirk. He resigned August 31st, 1975, because he faced impeachment by the Florida legislature after he had been accused of putting pressure on lower court judges into granting favorable rulings for his friends and political supporters, end quote. So none of these words are mine. They're from the New York Times and the St. Pete Times. They're from noted sources and from historians. They tell us the history of this, our state, and they tell us back in the 70s and in history, there was legitimate concern of corruption on the Supreme Court of the state of Florida. Thank God that's no longer true. But since back then it was true, the people rose up. They changed the jurisdiction of the Supreme Court of Florida. They created a system where, as you saw from our discussion of controlling versus persuasive precedent, very often ultimate issues are not decided statewide by the Florida Supreme Court. They're decided by the district courts of appeal. That's why I say, from a historical standpoint, corruption has its price. And I know I sound dramatic in saying that, but it is through that drama that I help you remember a most important point, and that is the Supreme Court of Florida does not have jurisdiction to either grant or deny or even consider a petition for writ of certiorari, even though it's been estimated that more than 90% of the cases that the Supreme Court of the United States resolves got there through a petition for writ of certiorari, even though that's their, if you will, number one tool in the federal system. Here in the Florida system, our Supreme Court of Florida does not even have that tool of certiorari at its disposal. So that's how you can remember that. A petition of writ of certiorari is a type of discretionary review. What is a petition for writ of mandamus? On the big board, we have a short definition. The elements of a petition for writ of mandamus are well enumerated by a book called Florida Elements of an Action, available wherever fine books are sold, and quoted in your textbook here. But to summarize the details of that quote, we might say that a petition for writ of mandamus seeks to remedy a government's failure to do something it is supposed to do. A petition for writ of mandamus seeks to enforce a clear legal right to the performance of a clear legal duty. So this is a direct answer to the question that started our lecture 1 hour and 12 minutes ago. How do I force government to do and compel government to do what it's supposed to do? One of the answers is by use of a petition for writ of mandamus. There's also a writ of prohibition. A writ of prohibition is a means by which to seek a greater court's order, preventing a lesser tribunal from doing something it should be forbidden to do. I've got a court that's out of control. I've got a court that's exceeding its jurisdiction. I've got a court that's running rampant over rights. I need not just sit back and lament. I can file a petition for writ of prohibition. Again, the elements of that action are outlined in great detail in your text. In summary, a writ of prohibition is a means by which to seek a greater court's order, preventing a lesser tribunal from doing something it should be forbidden to do. You don't have to wait to file an appeal. If you can qualify for a petition for writ of prohibition, you could act immediately. What's a writ of quo warranto? That's a Latin phrase. If I were to guess at its translation, I would think it would be quo like in who, warranto like in authority, like what warrants that. And indeed, a petition for writ of quo warranto is an action to challenge the exercise of some right or privilege, the peculiar powers of which are derived from the state. Can I use a petition for writ of quo warranto against a state actor, someone who has the authority of the state and is using the authority of the state? Yes. Yes, I can. Can I use a petition for writ of quo warranto against someone who doesn't rightfully have the power of the state but is using state power? Yes. Yes, I can. So it's two different types of actors, one that legitimately has the power and one that illegitimately is using the power. Either one of those actors can be subject to a petition for writ of quo warranto. What's a constitutional writ? Also called the all writs power. When we went over the different courts and we quoted the Constitution from Article 5, we saw that many of them ended with an all writs necessary. That's the all writs power. A constitutional writ, this all writs power, is an original action filed to preserve a court's jurisdiction that's already been invoked, or to protect a court's jurisdiction that will likely be invoked in the future. So you've already filed your notice of appeal, but the lower tribunal is taking actions that's going to make your appeal moot. You want a petition for constitutional writ. You want to invoke the all writs power. What if you haven't filed that appeal yet, but they're taking such action? Again, you might be able to meet the elements of and qualify for the granting of a constitutional writ, the all writs power. One catch to remember, ladies and gentlemen. With one exception, one type of writ of certiorari, every constitutional writ and all of the extraordinary writs that we cover are within the discretion of the court. If you meet all the elements of the action for your writ and you've successfully proven them all and you have persuasively presented your case, the court in its discretion might still deny issuance of the writ. That's an important caveat, and it's true for all of these writs except for one type of writ of certiorari, which we'll cover in just a moment. But I don't want to deny you the thing that you've longed to do for so many weeks, and that is to be a contestant on everyone's favorite game show. Name that writ. But of course, we have our first contestant, Anthony. Thank you for saying, "Here I am, it is I am lead counsel. Call on me." Yes, I will, sir. Are you ready to play everyone's favorite game show? Name that writ. All right, let's play. While scheduling the bench trial in your Florida County Court civil case, Judge X says, "I'll just hold trial for an hour. That's long enough for your client to feel like he got a fair trial before I rule against him." I worked so hard on that laugh. After hearing this, Judge X denies your motion to disqualify Judge X. Sounds like time to file an extraordinary writ, which of course means, Anthony, name that writ. Which one of these writs do you file under facts such as these? Give Anthony our choices. Come on, give him our choices. What do we got? Mandamus. What else we got? Prohibition. What else we got? Quo warranto. What else we got? Certiorari. What else we got? Constitutional writ, the all writs power. Habeas corpus. Yeah, it's not in this game show, but it's one of them. Yeah. To at least remember, okay, even though Anthony might prove all the elements of that action and be entitled to it, court can still deny it in the discretion. Another thing to remember, we're allowed to plead in the alternative. So you're not sure, you call that one petition a bunch of things. The rules of appellate procedure in Florida say that if I gave it the wrong name, but I proved the correct elements, the court can rename it and grant it. Whew. So McGinley, if that's true, why do I got to name that writ? Well, here's the practical problem. If you thought it was this writ, and all you offered was evidence of that writ, even though the court can correctly know, oh, no, it's actually this other writ, you might not have proven those elements. You see, from a practical standpoint, that rule that the court can rename it for you might not save you. So that's why what you really have to know is to be able to name that writ. You've got a question, but what about my question? I want you to name that writ. Are you naming that writ? You gonna name that writ? What are you gonna name? Anthony says it's a writ of prohibition. What do you say? The answer is writ of prohibition. Why writ of prohibition? Why was that the right choice? A prohibition action is a means by which to seek a greater court's order, preventing a lesser tribunal from doing something it should be forbidden to do. Should a lower tribunal be permitted to put on a farce of a trial? Should the judge literally say, I'll hold trial for an hour. That's long enough for your client to think he got a fair trial, and then I'm going to rule against him. Should a court be allowed to do that? Of course not. Yes, your question.
So couldn't this also be a writ of mandamus?
No.
Not at all?
You want a writ of prohibition. Tell me why you would have went with a writ of mandamus. Of course, you would have called your one petition for writ of prohibition or mandamus. And then within your 50-page limit, or sorry, I'm talking old-fashioned. Now it's a word limit, 40,000 word limit. You would prove the elements of both. But tell me why you would have thrown in the other one.
Well, because for element one, he's got a right to a fair trial.
Yeah, it sure does.
For element two, the judge has to rule on his motion. And
True. But what's the remedy for mandamus? It's an order telling him to do something. What we want here is an order telling him not to do something. He's biased. He's going to rule against my client. I filed a motion to recuse. Remember, I did that in the hypothetical, and it was denied. I did that before I tried my writ. So he's about to hold a hoax, a farce, a pretend trial, just long enough for my client to think it was real and then rule against him. I got to stop that. I got to prohibit that. I need a writ of prohibition.
But so the writ of mandamus, couldn't it be an order telling the judge to recuse himself? That would be making him do something, him or her.
Yeah, okay, all right. But basically, you want to prohibit him from presiding. A writ of prohibition can remedy, for example, a failure of a judge to disqualify himself. The case law tells us that. It can remedy a state agency acting in excess of its jurisdiction. We see that in the Florida case law precedent. Prohibition can remedy a court acting in excess of the court's jurisdiction. We see plenty of Florida case law precedent on that. Prohibition can remedy the fact that the lawyer is about to be cited for contempt. If, God forbid, you're ever in a situation where a judge does an order to show cause, makes you come before her or him as to why you shouldn't be cited for contempt, certainly you want to call your friendly neighborhood bar grievance defense attorney to help you out, 407-681-2700. One of the options we'll discuss is whether, in addition for preparing for that hearing, we also want to file right now a writ of prohibition to prevent that hearing from ever happening. 2 bites at that apple. On these facts, where do I file my writ of prohibition? This was a county court judge. Now, we know the Supreme Court can issue writs of prohibition, so we'll start there, right? Constitution says they have jurisdiction, but we don't start there. District courts of appeal have jurisdiction, Constitution says so. I'm quoting it right here on the big board. But we don't start there. Circuit courts also have jurisdiction. Constitution says so, and that's where we start. McGinley, come on, man. Let's start at the top. Florida case law precedent says that's not what we do. Although all three levels of courts have jurisdiction, only one level of court will exercise that jurisdiction. The lowest level of court, consistent with the welfare of this case, will exercise that jurisdiction. The lowest court that has territorial jurisdiction is the only one that will exercise its jurisdiction. Yeah.
What if the circuit court is also evil and denies it?
Oh, yeah, that's coming later in my hypothetical. I'll eventually get there. Man, great minds think alike. You're going to file an extraordinary writ to seek review of the outcome of the extraordinary writ. Right? I'm also your friendly neighborhood board-certified appellate attorney. I know how to stay in business. If you lose the appeal, you appeal from the appeal, right? That's supposed to be a joke. No one laughed. Okay, anyway. Venue for any extraordinary writ generally follows territorial appellate jurisdiction. So the court with territorial authority in the first instance to review that entity's final orders or judgments, that's the court that'll exercise its jurisdiction to enter the extraordinary writ, such as in this case, a writ of prohibition. Other courts, as you saw in the language of Florida's Constitution, they have jurisdiction, but they won't exercise that jurisdiction. Because of judicial economy, the next court up, the court that would have been the appellate court from a final judgment, that's the court that's going to exercise jurisdiction. Get it? So in this case, we know that we were in Orange County. That's in the Ninth Circuit. So that's where we're going to file for our extraordinary writ. Anthony, you got the first one right. Want to press your luck? Want to continue to play? Name that writ. Your enthusiasm, man. Tone it down. I should say it to myself, right? Yeah, back at you. Okay. You win your writ of prohibition from the order denying motion recused Judge X. So now you're back in front of Judge X upon remand. Judge X sets the case for trial in front of Judge X. What? So you file a motion to enforce the appellate mandate and transfer case. Judge X denies the motion. Name that writ. Well, first of all, you might not need the writ if it's still within the motion for rehearing stage and there's still jurisdiction at the appellate court that issued the writ. You can file with the appellate court a motion to enforce the mandate. Or in the alternative, that jurisdiction no longer exists, you can file another extraordinary writ. Which one is it? The constitutional writ. You invoke the court's all writs power. You can do that even after the 30 days. A petition for constitutional writ is an original action filed to preserve a court's jurisdiction that's already been invoked, or to protect a court's jurisdiction that will likely be invoked in the future. Here, we already invoked that court's jurisdiction. They said, don't do that. And the trial court said, I'm going to do that. Constitutional writ can be used for many things, including to stay lower court proceedings, to enforce an appellate mandate, to enjoin or stop an action that would prevent the higher court from exercising its jurisdiction. Where do I file it? Remember the rule. Even though the Supreme Court has jurisdiction, you see it here in the language of the Constitution, quoted right there. Even though the District Court of Appeal has jurisdiction, you see it here in Florida's Constitution and the language quoted right there. The Circuit Court has constitutional jurisdiction and is the lowest court with territorial jurisdiction over this particular tribunal. So that's the one that will exercise its jurisdiction. Although more than one higher court has jurisdiction, the only court that will exercise that jurisdiction is the court with territorial jurisdiction over appeals from final orders of the lower tribunal. So where do I file? Again, I'm going to file it in the Ninth Circuit. Anthony, you're 2-0. Come on, man. Press your luck. You ready? Name that writ. You win your constitutional writ, your all writs power appeal from the order denying the motion to enforce the appellate court's mandate. So now you're back in front of who again? Judge X. You two must get along great by now, huh? Yeah. It's one of the reasons you hire your friendly neighborhood board certified appellate attorney so that he or she can do the dirty work, right? Yeah, but you did your own appeal, so now you're back in front of Judge X on remand. And Judge X enters an order transferring the case to Judge R, who is Judge X's sister. You see, Judge R retired years ago and has no longer been elected by the people of that county. But Judge X enters an order, and Judge X makes some findings. Judge X finds there just aren't enough active judges in Judge X's county. Judge X also finds that the governor was wrong not to call Judge R out of retirement. So the order says Judge X is doing what the governor should have done and what the people need to have done. And by necessity, Judge X is appointing Judge R to preside over the case. So technically, we've finally complied with the two extraordinary writs, right? But now what does Judge R do? Judge R denies your motions, objecting to Judge R presiding. Anthony, sir, name that writ. Anthony suggests that the correct writ is quo warranto. Anybody agree? Correct? Yes, the correct answer is quo warranto. That is correct. I mean, like, on whose authority can Judge X appoint Judge R? Maybe roughly, very roughly, I don't speak Latin, wish I did. Translating the Latin quo warranto would say, what warrants that? On whose authority? A petition for writ of quo warranto is an action to challenge the exercise of some right or privilege, the peculiar powers of which are derived from the state. Quo warranto can be used, for example, you see in the case law, to determine if a state officer or agency improperly exercised its power, to challenge a right to hold a public office, to challenge a right to hold a government franchise. But where do I file it? The Supreme Court does not have jurisdiction this time. It can issue writs of mandamus and quo warranto to state officers and state agencies. Judge X and Judge R, most relevant in this hypothetical Judge R, is a county court judge, or alleges to be. That makes her a county officer, not a state officer. So the Supreme Court of Florida does not have jurisdiction. Does the District Court of Appeal have jurisdiction? Yes, it can grant such a quo warranto. Does the Circuit Court have jurisdiction? Yes, it can grant a quo warranto. The rule's the same as always with writs. More than one higher court has jurisdiction, but only one may properly exercise that jurisdiction. Note that the Florida Supreme Court's quo warranto jurisdiction is limited to state officers and statewide agencies, so it's not one of the courts that even could exercise the jurisdiction because it doesn't have it. But within that limit, use the usual rule for writs and choose the lowest appellate court with territorial jurisdiction, which is going to be which? Same court you were in the last two times you had a problem in this case. The Ninth Circuit sitting in its appellate capacity. Anthony, you're doing great. You ready for the next one? Name that writ. Number 4. You win challenging Judge R's entitlement to serve, and upon remand, the presiding judge becomes Judge Y. Right. You let Judge Y know through appropriate pleadings that the cause is at issue and you are ready for trial. She takes your motion to set the trial date under advisement while she, quote, thinks about what's right to do in a complex civil case like this. 9 months later, I mean, you could have had a baby by then, right? 9 months later, your renewed motion to set the trial is denied so that the judge can think some more. I'm back to the question that started this lecture 1 hour and 37 minutes ago. I don't know how y'all put up with me. These are long classes, right? But I try to keep them lively. And that question was, how do I compel the government to do what it's supposed to do? As a lawyer, how do I do that? So in this particular case, this judge has got to do a simple thing. Give me a trial date. And won't. So Anthony, name that writ. You are correct, sir. And please note that he said that before I turn the slide. Yeah. All right. The correct answer is petition for writ of mandamus. Petition for writ of mandamus seeks to remedy a government's failure to do something it's supposed to do. Mandamus seeks to enforce a clear legal right to the performance of a clear legal duty. My case has been pending. The cause is at issue. We are ready for trial. I have filed appropriate motions to ask for a trial date. It's just a ministerial thing. You're just supposed to pick a date on your calendar, Judge. Maybe later you'll pull the plug and cancel it, but can you please pick a date on the calendar now? Because the law says I have a clear legal right, and the law says you have a clear legal duty, and if you don't, I can file a petition for writ of mandamus. Mandamus can be used, for example, we see in the Florida case law, to compel a ministerial, non-discretionary act. Government can be sluggish. Government can be reluctant. Good enough for government work. You know, government doesn't always get the job done. This is a way when there's a ministerial, non-discretionary act to compel and force the government to do what it's supposed to do. You can force the government to issue a license or a permit. Not a particular terms of a license or a permit. If I'm entitled to a driver license, I can compel the issuance of a driver's license. It may or may not have a CDL, commercial driver license endorsement. It may not have a hazmat or twins endorsement. It may have a requirement that I wear my eyeglasses when I'm driving at night. I can't dictate the terms of the license through the petition for writ of mandamus. But to the extent that I'm entitled to some sort of license, I can get an order compelling the issuance of a license. I can compel a lower tribunal to decide an issue. Through the mandamus process, I can't compel it to decide yes or to decide no, but I can compel it to decide. And here's an interesting one. The case law in Florida says that a writ of mandamus can be used to find a state statute facially unconstitutional on its face. It's interesting use of the mandamus, but it can be done. Where do I file it? You know the answer. Supreme Court doesn't have jurisdiction. This DCA has jurisdiction. Circuit Court has jurisdiction, but the only one that's going to exercise it is the usual rule, the one with territorial jurisdiction over final orders rendered by the court against which you want the writ entered. So yet again, I'm back to the same place. I'm back to the Ninth Circuit Appellate Division. Name that writ. You win your appeal from the order denying the renewed motion to set trial. And county court judge does what county court judge should have done before, sets your client's trial for March 17th. I'm an Irish American. My grandparents that came over from Ireland, County Donegal. So I know that March 17th is St. Patrick's Day. Maybe you know that too. When you show up on St. Patrick's Day, armed protesters from this fictitious made-up group I just made up called Respect St. Patty's Day have occupied the county courthouse, claiming it as their own. People with guns can do things like that. They block your client and the judge's access to the courthouse. You can't even physically get in. And how have they done that? With a tall fence that is green, of course. Anthony, in this most preposterous hypothetical, which could never really happen in the real world, name that writ! Quo warranto. Who has the right to put up a tall green fence and stand in front of the guns and keep me and the judge and the opposing counsel out of the courthouse? But wait a minute, Respect St. Patrick's Day, this group, they were never duly elected. No, but they're exercising the authority of the state. That's state property, that courthouse. These are state employees they're keeping out of that courthouse. No, they weren't duly elected, but they're exercising the right of the state so they can be subject to quo warranto. Before the DCAs and the circuit courts, quo warranto is available to challenge the exercise of some right or privilege, the peculiar powers of which are derived from the state. So the respondent need not have state power. The respondent only needs to be using such power. And in our hypothetical, that's what's going on. Yes?
So this says that the power is derived from the state, though. Wouldn't that be given from the state?
Sure, that's how we covered at the beginning of our lecture how Florida's Constitution created a state court system.
Yeah.
That's where the power to have a courthouse came from. Respect St. Patty's Day took it over. Now it's their courthouse. They don't legally have the right, but they are usurping a state power that is derived from the state.
But would it derive from the state mean that it was given to them?
Hey, calm down. This is such a preposterous hypothetical. It could never really happen. But I'm trying to illustrate that this writ is not just available against someone who is duly elected. It's anyone who's using the power of the state. Maybe my hypothetical is a little off base, but trust me when I tell you, it's either a duly elected state actor or someone who's using the power of the state. Where do I file this petition for writ of quo warranto? Again, same place. Why is that? You know the rule. Even though more than one court has jurisdiction, the only one that will exercise that jurisdiction is which? The lowest ranking court that has territorial jurisdiction over this issue. We got time for another. You want another? All right, that's enthusiasm. Name that writ. After you win your appeal, ousting the occupiers from the courthouse, County Court Judge Y enters an order disqualifying counsel, finding you have a conflict of interest, and instructing your client to go hire someone else. Judge Y denies your and your client's motion for reconsideration of that order. Name that writ. Of course, the answer is certiorari. Certiorari? Yes, certiorari. A petition for writ of certiorari is used to seek review of an order from which an appeal is not immediately available. That order has to depart from the essential requirements of law. Got that in quotes because it's one of the legal standards. It must cause great harm. Sometimes the case law says irreparable harm. And you must prove that there is no other adequate remedy that exists. Oh, but they can hire a different attorney. But that attorney's not as good as you. There's no adequate substitute for you. Come on, have some self-esteem here, people. So this is one of the case law examples where certiorari applies. It's granted to review orders compelling discovery despite a privilege, denying discovery if there's irreparable harm from that denial, denying a motion to dismiss for pre-suit failures, granting or denying a motion to disqualify counsel. Our clients have rights. They have a right to choose us. We can enforce that right. Certiorari is denied and cannot review orders that grant or deny irrelevant discovery, that grant or deny trial by jury, that grant or deny claiming punitive damages, that grant or deny overbroad discovery. 2 points to make before we go. You read the text. You know that this is not the only type of certiorari. There's 2 other types of certiorari. What's the other type of certiorari? The Butch case illustrated it well. Second tier certiorari. What's that mean? That means if you don't like the outcome of the petition for writ of certiorari, you go to the next highest court by filing with it a new petition for writ of certiorari, challenging the outcome of the first petition for writ of certiorari. Cool, right? We're still in business, yeah. But it's not a mulligan. It's not a do-over. It's not a new petition for writ of certiorari. As the Butch case illustrates, you got to show either one of 2 things. You were denied procedural due process. They ruled on the case without telling you procedural due process, or they applied the wrong law. If they applied the right law and you don't like the outcome, that's not enough. They had to have applied the wrong law. So now you know about 2 types of certiorari. You know about petition for writ of certiorari, and you know about second tier petition for writ of certiorari. What's the third type? This is a certiorari from an administrative order that is not appealable under Chapter 120, the Florida Administrative Procedures Act. There are certain local decisions of local governments that don't meet the definition of agency, which is a wicked broad definition under the Florida Administrative Procedures Act. How do you appeal, if you want to call it an appeal, from such a local government decision? You file a petition for writ of certiorari. Here's the kicker. Unlike the petition for writ of certiorari that was second tier, which made it harder, this petition for writ of certiorari makes it easier. For this particular writ of certiorari, the court has to grant relief if you prove the elements. Remember, I said there was one exception to the extraordinary writs, all of which were discretionary. You could lose even though you proved the elements. This is that exception, this type of certiorari. And under this type of appeal, you get to challenge the findings of fact. You can only challenge that they are not based upon competent substantial evidence, but unlike any other extraordinary writ, finally, you can challenge a finding of fact. And with that said, I'm proud to say that after all these 7 weeks, I have not, NOT, not fallen behind the syllabus. I am exactly where I'm supposed to be according to our syllabus. So I'm on track. We're going to cover everything you need to know in this class. We're going to prepare you well for the Florida bar exam, but most importantly, we're going to empower you to be able to make government do what it is supposed to do. Stick with me. as we cover separation of powers and 2 other chapters all in one class next week. And until I see you then, may God continue to bless us all. Thank you very much for being here.